Namaskar, dear friends. Once again, I welcome you into the topic of silent features and characteristics of Indian Constitution, prepared by One Stop All Solution. This is my channel. So, if you like this channel, please subscribe it and don't forget to click the bell icon. So, here we go to the topic. In our last lecture, we have conducted 12 points related to the silent features and characteristics of Indian Constitution. In the part second of this lecture, we are going to see the remaining 11 points connected with characteristics and silent features of Indian Constitution. So the next one, that is 13th point, is that uh, as characteristics or silent features of Indian Constitution is emergency provisions. Indian Constitution describes emergency provisions of three kinds or three types. So which are they? Under Article 352, it speaks about national emergency. Secondly, Article 356 speaks about the state emergency if there is failure of constitutional machinery in the state. And the third type of emergency is defined under Article 360, which speaks about financial emergency which is not yet imposed in India. So we are having three kinds of emergency. One is national emergency, second is state emergency due to the failure of political machinery, and third is financial emergency. The next characteristics is adult suffrage. So every man and woman above 18 years of age has been given a right to vote. This provision has been added to Indian Constitution by 61st Amendment Act 1988, which has reduced the voting age from 21 to 18 years. It was indeed a very bold step on the part of the constitution makers to adopt adult suffrage, wherein even illiterate people are also entitled to vote. That means from 61st Amendment Act 1988, this power to right to vote has been given to illiterate people also. Previously, it was not so. Now, after this, we are having a characteristics and silent features related to preventive detention. Now, our Indian Constitution has provided for adequate safeguards against the arbitrary discretion of executive or legislature, that is under Article 22. In case of preventive detention, if the procedure given under Article 22 is not followed by the executive authority, then the detention in question is called unconstitutional. Here, state is also empowered to enact a law providing for preventive detention of persons, even during peacetime, for reasons connected with the defense, foreign affairs, security of the state, etc. In India, our preventive detention has acquired a constitutional status, and that is why this characteristic has been mentioned in our constitution. Next is we have got single citizenship according to our Indian constitution. And rightly here we can say that the constitution provides for single citizenship, that is the citizenship of India to every citizen in India. Secondly, as it has been rightly described that in India, state citizenship is not recognized. So we are having only single citizenship. So different states are there. Those states are not providing or recognizing any citizenship. Thirdly, every person can claim only one citizenship, and that is called citizenship of India. Every Indian can enjoy practically the same civil and political rights of the citizenship, no matter in which state he resides. Whatever may be his state of residence, he will enjoy only one citizenship, and that is citizenship of India, where he can enjoy practically the civil and political rights equally. Thus, even though the Constitution of India is a federal, and provides for a dual polity, that is union and the state, but it provides for a single citizenship for whole of India. As compared to the American Constitution, there is in America a dual citizenship, but in India we are having a single citizenship. So we don't have the state citizenship which has not been recognized according to Indian Constitution. The next characteristics is we are having independent agencies. Independent agencies, the Indian Constitution provides for certain independent agencies which are executing their work without any kind of control by the executive authority. Here, these authorities are totally immune from any kind of executive interference. These authorities are discharging their vital role in democratic government like India. We can see certain example that what kinds of authorities are there. Here, Comptroller and Auditor General of India is there. The Election Commission is there. The Public Service Commissions are there. Lok Ayukt, etc. is there here, which are acting as certain independent agencies where there is no interference of any executive because they have been immune from uh, interference of these executives. The next characteristics is minorities and backward classes. As Indian Constitution is covering number of points in it, it is also providing the chapters related to minorities and backward classes as well. So in India, there exist various religions, various languages and cultures, etc. There are some sections of people who are weaker than other. They may be economically weaker, they may be socially weaker, they may be culturally weaker. So for them, our Indian Constitution contains very liberal schemes to safeguard the minorities and backward classes. There are a number of provisions which has been provided over here for the benefit of these minorities and backward classes, and those benefits have been given under articles 16 subclause 4, article 29, article 30, etc. So in as a characteristics, our Indian Constitution has made provision related to minorities and backward classes as well. Further, the next characteristics of Indian Constitution is that our Constitution is a socialist constitution. Socialist states are there. The term socialism literally means a political system which advocates state ownership of the means of production, distribution, and exchange. The concept of socialism. Here, every state which is doing the production, the distribution, and exchange with other state. So, the concept of socialism stands over here. The word socialist was not there originally in the preamble of Indian Constitution, but it was added to the preamble by 42nd Amendment Act to the Indian Constitution in 1976. So in India there is a democratic socialism. Here we have to see one case law of Supreme Court in GB Pant University of Agriculture versus State of UP AIR 2000 Supreme Court 2695. The Supreme Court said that democratic socialism in India aims to end poverty, ignorance, disease, and inequality of opportunity. Here, socialistic concept of the society should be implemented in the true spirit of the Constitution. So that is why Supreme Court has explained related to the democratic socialism, which was the social aspect of our Constitution. Further, secular state was the concept which was also inserted by 42nd Amendment Act 1976 in Indian Constitution. Here, the term secularism means that there is no official religion of India. India as a state will treat all religion equally without any kind of discrimination. There is no state preferred religion as such. Here, no specific protection has been accorded to any religious group. As such, several provisions are made with a view to protect secularism in India. For example, Article 25 to 28 of the Indian Constitution has given concrete shape to this concept of secularism. Here we can see certain cases. Number one, S.R. Bommai versus Union of India, AIR 1994, Supreme Court 1918. A 9-judge bench of Supreme Court has observed that the concept of secularism was very much embodied in our constitutional philosophy. And the court held that secularism is the basic feature of Indian Constitution. Then in Valsamma Paul versus Cochin University, AIR 1996, Supreme Court 1011, the Apex Court emphasized that intercaste marriages and adoption were two important social institutions through which secularism would find its fruitful and solid base for an social order under the Constitution of India. So in this way, we can know that the secularism concept was present in India and it was later added to the Indian Constitution, that is the preamble, under the preamble of Indian Constitution. So that is why the word secular was not present originally in the preamble of the Indian Constitution, but it was added thereto by 42nd Amendment Act in 1976. The next characteristics here is that doctrine of judicial review. As earlier we have known that doctrine of judicial review, we have taken this concept of doctrine of judicial review from the Supreme Court of USA. Now here, doctrine of judicial review is also one of the silent features of our constitution. It means that courts have been given the power to examine laws and executive acts and test their conformity with the constitution and struck them down if they are found to be inconsistent with it. According to Article 13 subclause 2, which provides that the state shall not make any law which takes away or abridges the fundamental rights, and any law made in contravention of this provision shall to the extent of the inconsistency be void. And further it is said that in Minerva Mills versus Union of India, AIR 1980, the Supreme Court has held that judicial review is the basic structure of the Constitution. The power of the judicial review vested in the Supreme Court under Article 32 and the High Courts under Article 226 is essential and integral feature of the Constitution, which ordinarily can never be outstayed or excluded. So in this way, we can know that our Indian Constitution is having a power of doctrine of judicial review in it. Now the next characteristics is that doctrine of basic structure. Now Supreme Court has made it clear that the Constitution, not the Parliament, is supreme in India. It means that Constitution is supreme, not the Parliament is supreme. According to this doctrine, there are certain basic features of the Constitution which are immune from the power of the amendments given to the Parliament by Article 368 of the Constitution. This doctrine has been developed by the Supreme Court of India. Here we are going to look into the case of Keshavananda Bharati versus State of Kerala, AIR 1973, Supreme Court 1461. Here the judges have mentioned as the basic foundation and structure of the Indian Constitution. Number one, supremacy of the Constitution is there. Second, separation of powers have been there. Third, secular character of the Constitution. Fourth, federal character of the Constitution. And fifthly, a republican and democratic form of government is the criteria which has been fixed by them under the doctrine of basic structure. And last characteristics of this Indian Constitution is doctrine of rule of law. In Indian Constitution, it embodied the modern concept of rule of law with establishment of the judicial system which should be able to work impartially and free from all the influences. The rule of law here means government on principles of law. Who is ruling to we people? Law is ruling. And this law has been made or created depend upon principles of law. Certain principles are going to be get followed before creation of these laws. And lastly, the rule of law prevails over the entire field of the administration, and every organ of the state is regulated by the rule of law. Here we are finishing our topic of silent features and characteristics of Indian Constitution.